Hello everyone and welcome to Legal Eagle. In today's session, we will be talking about the polluter pays principle in environmental law. So first, let's define what this principle is all about. The polluter pays principle is a legal principle that requires the party responsible for causing environmental damage to bear the cost of mitigating or cleaning up that damage. This means that if a company or individual pollutes the environment, they are responsible for paying the cost associated with cleaning up that pollution. It is a commonly accepted principle in international environmental law, which entails that those who produce pollution should bear the cost of managing it to prevent damage to human health or the environment. Under this principle, it is a responsibility of polluting party to meet the cost involved in prevention of environmental damage and in carrying out remedial actions regardless of any intent. The Organization for Economic Cooperation and Development, which also stands for OECD, defines PPP as an instrument for allocating the cost for pollution prevention and control measures. The polluter pays principle was adopted by the Organization of Economic Cooperation and Development in 1972 as an economic principle for allocating the cost of pollution control. Subsequently, the Rio Declaration laid down the guidelines for sustainable development. Within the Rio Declaration, Principle 16 of it was the polluter pays principle, stating that the polluter should bear the cost of pollution. Plato has rightly stated that if anyone intentionally spoils the water of another, let him not only pay for damages, but purify the stream or cistern which contains the water. Now, why this principle is important? Well, it helps to ensure that those who profit from activities that harm the environment are held accountable for the resulting damages rather than society as a whole. It creates an incentive for companies and individuals to take steps to prevent or reduce pollution, as they will be required to pay for any negative impacts on the environment. The polluter pays principle requires either government intervention or the presence of clearly defined property rights. Example: if someone has access to a river, they can sue a chemical producer if they create a cost of pollution. For other goods, it is harder to define property rights. For example, the pollution from a car affects everyone in society and also other countries. In this case, it is impractical to extend property rights to try and deal with the problem. The pollution faced by individuals is relatively low. In this case, government regulation is the only effective method. So what are some examples of how the polluter pays principle is applied in environmental law? One example is the cleanup of oil spills. If an oil tanker spills oil into the ocean, the company responsible for the tanker is responsible for paying for the cost associated with cleaning up the spill. This could include costs such as hiring cleanup crews, purchasing specialized equipment, and compensating affected communities. Another example is the remediation of contaminated land. If a company has polluted a piece of land, they may be required to pay for the cost of cleaning up that contamination. This could include the removal of contaminated soil, the treatment of contaminated water, and the restoration of the land to its original condition. Overall, the polluter pays principle is an important tool for promoting environmental protection and sustainability. It helps to ensure that those who profit from activities that harm the environment are held accountable for the resulting damages and encourages company and individuals to take steps to prevent or reduce pollution. Thanks for watching. If you have any questions about the polluter pays principle in environmental law, leave them in the comments below. Don't forget to subscribe the channel and share the video. Happy learning!